Hello, everybody. How are you? First order of business, roll call. Let me know that you're present. Type something in the comments so I can make sure you're all present and accounted for. So, second order of business, we're going to get into the Assange High Court hearing. So, where to begin? This is it was a long day, so bear with me. So, you know, I just like the extradition hearing last year in London at the Old Bailey, and the ruling on January 4th, and then the bail hearing, and then the preliminary appeal hearing on August 11th, and then, you know, today we had the full appeal. I covered all of this stuff, and I attended the High Court hearing remotely. Okay, so I'm going to break down to you what happened, why there was court today, what's going on, where is the extradition case, at what stage it's at, and this is not going to be a short video. You know, if there's going to be a long video, it's this stuff, because this is a court case, right? Not to mention a highly complex political case, and so I want to take the time to break things down in detail, properly. I want to take my time with it. You know, I'm not attending court right now. I don't have to rush with it. So, you know, I'm going to take my time with it. So this is really something that has to be broken down so people understand, because it's insane. So I'm just going to show you a bit of the thread that I did here. By the way, tomorrow we'll have court again, right? On October 28th, we'll hear from the defense tomorrow. So if you want to follow live while I'm in court, I can tweet. And I do these live threads, as do some of my lovely colleagues in independent journalism. And you should go on Twitter, follow me, Kevin Gostola, Stefania Morizzi, Mary Kostakis, Consortium News, Mohammed Al-Mazi, Tarek. They're all doing great work. And there are probably some that I forgot to mention right now, but so excuse me for that. But I want to get into the case and show you what happened today. Okay, so this took place at the High Court, also known as the Royal Courts of Justice, and you know, the audio, of course. Well, I won't talk about the audio right now, but why are we here? So in January, you remember Judge Barretza, she ruled against extradition. She said, no, Assange will not be delivered to the United States. Why? Because if he is sent to the United States from the UK, it's too oppressive. The conditions are too oppressive, right? The US prisons are inhumane. You don't have to be extradited to know that. But especially for Assange, who is being treated like a terrorist, even though he's a journalist, they will most certainly put him in, you know, egregious, difficult, horrendous prison conditions, right? So pre-trial, they'll put him in administrative segregation in Virginia and in Florence, and then in post-trial, once he's convicted, because it's guaranteed, it's a political trial, it's a show trial, of course they'll convict him, even though he's done nothing wrong. They will put him in ADX Florence in Colorado, which is, you know, it's been described as hell, because that's what it is. You go in and you're never going to see the sun again. So this is what she was talking about. And the other thing is that there's a heightened risk of suicide, which goes with the inhumane prison conditions, right? So today, what was the United States trying to appeal, since the judge said no? Well, they wanted to appeal on 5 grounds. I'm going to read them to you again to refresh your memory, okay? From A to E. So A, the first is that the judge made errors of law in her application of the test under Section 91 of the 2003 Extradition Act. Had she applied the test correctly, she would have not discharged Mr. Assange. What is Section 91 of the 2003 Act? So this is something that I had a feeling this would be used to block the extradition. When they brought it up in court during, you know, last year in September, I already knew what it was, because I'd seen what happened to Gary McKinnon. I interviewed him, and this is, of course, you know, the Section 91 is to prevent an extradition if, as we said, it's too oppressive for the inmate, for the prisoner. So there could be psychological or physical, right? And obviously, if you're going to be extradited to the United States to face 175 years, potentially, and thrown in an ADX, in a supermax, a federal supermax like ADX Florence, I think anyone would kill themselves. And so under Section 91, she barred extradition. And she, there are various reasons. She goes into that in her explanation. But they're saying that she erred in her application of the law, and that Assange, he does not meet the criteria for the threshold. And the second thing that the United States is saying, B, is that the judge, having decided that the threshold for discharge under Section 91 was met, ought to have notified the requesting state, meaning the United States, of her provisional view, so as to afford it the opportunity of offering assurances to the court. So what they're saying here, I'm translating from legal lingo into English. They're saying that if the judge felt that Assange meets the requirements of Section 91, meaning it's too egregious for his health to be extradited, she should have told them so that the United States could give assurances, which I'll get to what they said in a second, which, that's what they're saying, though. This is what they're saying in B, okay? C is that the district judge, Judge Bretzer, having concluded that the principal psychiatric expert called on behalf of the defense, Professor Koppelman, had misled her on a material issue, ought to have ruled that this evidence was inadmissible, okay? So, alternatively, if it could be said that his lack of independence went to weight rather than admissibility, the district ought to have attributed no or far less weight to his opinion as to the severity of Mr. Assange's mental condition. So what's going on here? I'm going to translate for you. Professor Koppelman is one of the key medical expert witnesses, right? So he's a renowned neuropsychiatrist from King's College, and he goes and spends time with Julian Assange to make a psychiatric evaluation, and he finds that Julian Assange is suffering from, MDD, GAD, PTSD, and Asperger's, ASD. And so however, he does one thing, which is a technicality. What does he do in a psychiatric evaluation? He interviews, people that know Assange, right? So I think his father, his partner, and this is, of course, the most important point, Stella Morris, his partner. Now, at the time, in his first report, okay, Koppelman did not disclose the identity of Assange's partner and children. So he mentions them, just partner and children, but he doesn't say who that is. And the prosecution is saying, well, clearly, Mr. Koppelman cannot be trusted because he hid the relationship between Stella Morris and Assange. What has that got to do with his medical opinion? I don't know. It beats me. It's a technicality. They're busting his balls about it. That's what's going on. They're trying to get this whole thing overturned on a technicality. And so what's interesting is that in his second report, which is, again, this is before the extradition hearing. So it's in August 2020, right? And the extradition hearing started beginning September 2020. So it's 1 month before, where he has a second report. He does disclose the identity because at this point it was already public. You've seen the CIA. We've had, again, confirmation now, once again, that they're trying to kill Julian Assange. Or at least they were considering it. Yes, they were considering kidnapping and or killing him in London. They also wanted to steal a diaper from his kid, like a shit sack, like this is the level of depravity. So of course, it's only natural that Professor Koppelman thought, why the hell would I reveal the identity of Assange's family, his children and his partner, so the CIA or whoever can go after them, or the media, the British tabloids could go after them? It's a disaster. So even the judge in her ruling in January, she agrees sort of with Koppelman. She said she understands why he did it. She called it an appropriate human response. Okay, that's what she called it. So she knows full well, and she still nevertheless agrees that Koppelman's medical testimony is the most valuable amongst all the doctors which we heard from, which are many. And so the United States is saying, no, this is inadmissible, and if it's not inadmissible, right? So if it's not completely excluded from the case, then at least the judge should give it far less weight, because she relied mostly on this testimony, medical testimony, to meet the threshold of Section 91. Now, the fourth ground, so D, is that the district judge erred in her overall assessment of the evidence going to the risk of suicide. So this is just in general, right? And E, the fifth ground, is the United States has provided the United Kingdom with a package of assurances which are responsive to the district judge's specific findings in this case. In particular, the U.S. has provided assurances that Mr. Assange will not be subject to SAMS or imprisoned at ADX unless he were to do something subsequent to the offerings of these assurances that meets the tests for the imposition of SAMS or designation to ADX. The United States has also provided an assurance that the United States will consent to Mr. Assange being transferred to Australia to serve any custodial sentence imposed on him. So they're trying to mitigate the damage here, right? They've lost the case because U.S. prison conditions are so inhumane. You know, there's a 99.999% chance Assange will be locked up in SAMS. Actually, I'd say it's 120%. And so they're saying, no, look, if Assange is extradited, we'll send him to Australia, which, you know, even if they were hypothetically to do that, would probably take years, right, to get through the formal process and then finally be transferred to Australia. And of course, they're still saying that they reserve the right to put him under SANS, special administrative measures, which is extremely, it's hell. It's the worst prison conditions. And we'll get to them in a second again, right? So I know perhaps some of you already know these things, but we have to go through this because, you know, it's a court case and we have to make things very clear. And so perhaps for those of you who already do, it's good to refresh your memory, you know? So let's go into the rest of what happened here, right? Because I'll play you these clips in a second. I just want to go through the proceedings, right? So the first thing that we have is Lewis QC, Queen's Counsel, right? So Lewis, he is representing the United States. He's the prosecution, right? He's an interesting character. And he says that you know, even despite not having given these assurances yet, he still thinks the judge made a mistake in her decision and she should have not blocked the extradition. Okay? And they say that she should have given the United States the opportunity to provide these assurances before. And as you can see, I point out here that they could have easily offered them before, but they didn't. And even the United States will admit that afterwards, inadvertently. And so we saw Assange for a second. Assange appeared in this blue room. He didn't come personally. It was a bit confusing at first because the court was informed that Assange would not be attending in person, only via video link. And then we understood he won't even be attending via video link because he doesn't feel well. And then we did see him, but only for a short while. So Assange, he was, let me try and paint this picture for you. You know, there's a blue room, a blue and white room. There's some red chairs, and Assange is wearing a white shirt and a black tie, or it could have been a dark red tie. I think it was likely black. Couldn't see exactly. The image wasn't too clear. And, you know, he's got long hair, his hand covering his face. He's sitting like this, you know, at one point. Yeah, he looks awful because who would not look awful if you were locked up in Belmarsh prison? It's the worst prison in England. So, you know, it was so messed up because I'm listening to, you know, they would cut from the court, from the High Court to Belmarsh so you could see Assange. And he's sitting there looking like crap, excuse the term, but he was sitting there looking awful. While the prosecution in the background, you can still hear the audio from Lewis, he's going off about how, oh, you know, Assange's risk of suicide was not that high. And, you know, he's basically accusing Assange of being a liar, a malingerer, someone who's pretending to be ill, right, to get out of something. And I'm looking at Assange like, this guy is not well. I can see it. Like, while you're talking, the contrast is unbelievable. It's such an eerie image, honestly. Really. Just something out of a movie almost, you know what I mean? Like, he's obviously not well, and it's because of you, because you've been persecuting him for a decade now. So anyway, we saw him for a bit, and then just going back to the argument, so Lewis, he starts saying that the court should not worry. Basically, his point is that the United States can be trusted, and he says there's a long history of cooperation between the UK and the US. Well, he's not lying there. And he says that the United Kingdom has never complained about the United States failing to meet its assurances, its diplomatic assurances, particularly regarding a prisoner transfer or something like that, right? And he says that if the United States were to give these assurances not to place Julian Assange under special administrative measures or SAMS, if the United States were to say that Assange could spend prison in Australia, that they should be trusted. That's what he's saying. And then he brings up Article 3 of the European Convention on Human Rights, which is it's pertaining to inhumane and degrading treatment. It forbids this, right? And so, of course, in order to permit the extradition, it has to comply not just with the Extradition Act, but of course the European Convention on Human Rights, which forbids. I mean, we have already went through this so many times. I could stay here literally all night going through the violations of the ECHR, the violations of the Extradition Act. This case violates every law you can think of. You know, British common law, American law, EU law, international law. You name it, it violates it. So, but particularly regarding Article 3. Lewis, for the prosecution, claims it's not in violation, okay? And he refers to a ruling. He's saying that, you know, basically being placed under ADSEG or administrative segregation and solitary, you know, it wouldn't violate this. I mean, then he goes on to say that the entire argument for the defense, for the psychiatric evidence, is predicated on the imposition of SAMs and detention in ADX Florence. So he's saying that the whole case that the defense has built regarding the psychiatric evidence is based upon the premise that once Assange were to be extradited, where would he go? He would go to ADX Florence. He would be placed under SAMs. And he's saying that, therefore, if there are no SAMs, if Assange is not placed in ADX Florence, then there should be no problem. Then basically the psychiatric evidence, it doesn't have that much weight anymore, right? He's saying you don't have to worry. We're not going to put Assange in you know, horrible prison conditions. We're not going to put him in a federal super maximum. So you all this psychiatric evidence that you've said about him, about a heightened risk of suicide and depression, it doesn't count. That's his argument, okay? He says the simple solution is this. Once SAMs and ADX Florence are removed, once there is an assurance of appropriate medical care, once it is clear that he, meaning Assange, will be repatriated to Australia to serve any sentence, then we can safely say the district judge would not have decided the relevant question in the way that she did. Okay? And so, then again, he goes on to say there's insufficient evidence that the United States would breach its assurances, that this is factually incorrect. And he addresses the argument from the defense that even if there were no SAM, solitary would be just as bad or oppressive to Assange, which, I mean, you really don't need to be a psychiatrist or a doctor to figure that one out. You really don't. I mean, you know, putting someone in solitary confinement is not exactly going to make them a happy person, right? So, not to mention someone who's already, you know, diagnosed, you could trigger something worse, and so on. But his argument is that in pretrial, you know, in the Eastern District Court of Virginia, in Florence, where they would have him most likely in pretrial, he would be placed not in SAMs but in administrative segregation, which is, you know, another way of saying solitary confinement. And he disputes this. He said, no, it's not really solitary confinement. And he refers to statements by Kronberg, which, if I'm not mistaken, because again the audio is quite terrible. If I'm not mistaken, we heard this last year. I'm pretty sure. I mean, I know we heard it last year, but I'm pretty sure that's what he's referring to. And so he talks about when Kronberg, so the federal prosecutor, AUSA Kronberg, referred to pretrial detention in Virginia, that he said that inmates in ADSEG are not in solitary. Why? Because they're allowed to speak to each other through doors and cells. They're allowed to meet with lawyers and attend programs. And this is, again, a lovely... This is, you know, lawyers love being creative. When they say that inmates can speak to each other through doors and cells, they mean if you scream like this, then maybe someone in the next cell can hear you. Technically, that's what they mean. So, I mean, this is ludicrous to say that this is not solitary confinement or not oppressive, because that's what it's about. It's not just about the term solitary or whether he's actually in solitary. It's about being oppressive to one's health. And that's the threshold to block the extradition and to look at. And saying they can meet with lawyers, they can attend programs. If I recall, Kronberg was referring to arts and crafts, right? This was their argument. Like, yeah, so what if we treat Julian Assange like a terrorist? There are arts and crafts programs so he can participate. Like, what is this? Who are you talking about? Like Osama bin Laden? What is this? So Lewis said there can be no argument that you're being held in solitary confinement if you've got a cellmate. You only go there for short stays. And this is, again, of course, you know, they're being creative here because we heard from expert witnesses called by the defense last year who worked in the U.S. prison system. You know, one of them, I think it was Maureen Baird was her name. She was the former head of MCC, right? So in New York, and she had prisoners under SAMS, and she knows about all this stuff and these regimens of how to treat prisoners. And you know, she just blew their whole case out of the water because she explained how everything is oppressive. You know, when we talk about them having cellmates, you know, you've had people at cellmates for like a few days and they yank them out and stuff them in solitary confinement. So this, again, they're just being creative. They're lying about this. So as I said here, the U.S. prosecution is trying to paint a rosy picture to the judges that Assange would not be housed in oppressive conditions, that there would be no solitary confinement, he'd be given medical assistance, and so on, right? And as I said, they're saying that they can trust the assurances, but this is absurd because there's a disclaimer here, and we'll get to that again, okay? So now he talks about Abu Hamza, right? So Lewis, for the prosecution, what does he do? He says, well, I know what you're going to say now. You're going to talk about Abu Hamza. The defense brought up Abu Hamza and said that the United States breached its agreement with Abu Hamza's lawyers not to put him in ADX Florence, which is this hellhole of a prison in Colorado where they will most certainly send Assange. And so look what he says here. This is incredible. He's saying this, not me. He just said this today in court. Look what he says. He says that the U.S. did not say that it would never house Abu Hamza in ADX Florence, just that it might not, and therefore this wasn't a breach of assurances. Yeah, I guess technically, but what is this? This is the game they're trying to play with Assange. This is why when they talk about assurances, it's worthless. It's not even worth the paper that it's written on, like Stella Morris says. And the prosecution is openly saying this in court. Because the next point, what is the next point they make? He says that the United States must reserve the right to place Assange under SAMS for purposes of national security. So he's saying that we're not going to put Julian Assange under SAMS, under these terrible prison conditions, but if he does something that we don't like, if he's a threat to national security, then we still reserve the right to place him under SAMS. Well, that's not really an assurance then, is it? Because they're gonna claim he's a threat to national security. The whole case is built on the premise that Assange is a threat, is a supposed threat to national security. He's not, right? And even when they're arguing about the First Amendment, isn't that refreshing going back to the like everything is about Assange's health now. There's nothing about First Amendment, nothing about journalistic freedoms, nothing about the crimes he exposed. Remember that. But just going back last year to the extradition hearing in the Old Bailey, the prosecution was saying, well, sometimes the First Amendment shouldn't be important because national security has to come first. Which is, well, if you're a journalist, you know what that means. You know what that means. And so, just like it was written in the assurances, look what it says here. The United States has provided assurances that Mr. Assange will not be subject to SAMS or imprisoned at ADX, unless he were to do something subsequent to the offering of these assurances that meets the tests for the imposition of SAMS or designation to ADX. So, again, this assurance is worthless because they are saying that they reserve the right to put Assange under SAMS, and it's arbitrary. What does that mean, were he to meet the tests for the impositions of SAMS? Could you elaborate? They never elaborate. They don't say anything in court. And of course, who do you think is going to decide whether Assange meets the tests for imposition of SAMS? The CIA. No, really. The CIA, whose files he published, right? Vault 7 in 2017, the Vault 7 files. The CIA whose crimes he exposed, kidnapping, torture, rendition. You think the CIA are not going to screw him? Come on. No one is that naive. You cannot look at this and be like, oh no, I'm not worried about how the CIA will treat him. They'll be fair. Come on. Are we playing games here? So you can see once again how, I mean, we knew this before already, but how in court, the United States is once again proving to us that their assurances are worthless. They're worthless. They not only show us that the assurances for Assange are worthless, but they even give us another example for free, Abu Hamza, where they screwed him as well. So Lewis then goes to talk about Section 91 of the Extradition Act, which, as we said, it blocks extradition if oppressive to the prisoner's health, okay? And this is a big point now because, again, this is the creativity of the lawyers. What are they saying now? So Lewis insists the court must consider Assange's current physical and mental state and not what it could be if extradited. He says Section 91 refers to a prisoner's current state. He says you have to take his mental health as it stands at the moment. Okay, so I'm just going to read you Section 91 under the Extradition Act between the UK and US pertaining to physical or mental conditions. So this section applies if at any time in the extradition hearing it appears to the judge that the condition in subsection 2 is satisfied. What does subsection 2 say? It says the condition is that the physical or mental condition of the person is such that it would be unjust or oppressive to extradite him. Okay? It would be unjust or oppressive to extradite him. But according to Lewis, he says that this is predicting the future. Yes, well, it says would. It doesn't say it. It's not talking about his current state. So I don't know how he arrived to this conclusion, but this is a big point now. So he's saying now that the doctors, the medical experts who said if you extradite Assange, he will kill himself. You will trigger a suicide attempt. He's saying this doesn't count. Because right now, is Assange too depressed right now? Is he too suicidal right now? Oh, no, he isn't? Okay, we can extradite him. This is his logic. I mean, I don't need to tell you how medically absurd this is. Again, I mean, this is some neurotypical bullshit if I've ever heard some, right? Like, I'm going to get to something else that is so ridiculous that Lewis also said about Assange's mental health. You know, does he know anything about mental health? I mean, if you listen to the doctors, there were many doctors who testified on Assange's behalf, right? And even those who were called by the prosecution admitted that Assange is depressed. I mean, I don't know what to say. It's just shocking. It's really shocking. And I just want to say that if he is talking about Assange's current state, well, it is bad already. You might recall there was a razor blade that was found in his cell, right? In Assange's cell. I'm going to get to all the doctors in a second, but this idea that he is not depressed enough right now or that he's not unwell enough right now is ludicrous because we heard from the doctors that in Belmarsh prison right now, he is not doing well. Yes? I mean, dude, I don't even know what that is like having so much pressure on you. Think about that for a second, like what it's like to be in his shoes. It's monstrous. It's monstrous to be under that pressure. And you have to consider he spent 7 years in the Ecuadorian embassy. We had, I think his name was it Cosby? Crosby, she testified. She's also a doctor. She testified on Assange's behalf about his physical state as well, right? And how he was unwell already in the embassy. He had, for example, I think he wanted to see a dentist and he couldn't go. And, you know, she was always worried if he's going to have a risk of infection, you know. So it's not just a mental thing, it's also a physical thing. And that qualifies under Section 91. It says physical and mental. And so in addition to that, we already know that his mental state is not well right now. Koppelman diagnosed Assange with generalized anxiety disorder, with Asperger's. He said there are he has traits that are similar to Asperger's. Dr. Deely diagnosed the Asperger's. But nevertheless, he said that Assange has traits of Asperger's. And he said that Assange has PTSD, right? So post-traumatic stress disorder and major depressive disorder, MDD. I mean, one of those is heavy enough, man. How much more do you need, right? So if their point is Assange is not well, right, is okay right now, this is not true. So as I said here, an eerie image. Assange is seen via video sitting in a blue room in Belmarsh prison, looking pale and sick, as the prosecution can be heard in the background, arguing to the court about his mental state, painting him as a malingerer. He's then escorted out the room by a guard. So Lewis says that the district court judge, that means Baretzer, who ruled in January, she applied too low a threshold regarding Assange's mental health. And as I wrote, in some sort of twisted benchmark, he cites examples of other cases with higher suicide risks. So this was incredible to me. I was genuinely confused for a second. I was like, what is his point? You know, he starts talking about other people who, according to him, and I mean, from what he said, I'm certain, had attempted suicide already or had higher risk of suicide. And I was like, well, what's your point? You know, like you want to drive someone to madness before they're sick enough for you not to kill them and send them to the US? Like this seemed really twisted to me in a way, you know, like he was basically saying, and remember, Lewis is not a doctor, right? And he's saying, Assange is not sick enough because he hasn't tried to kill himself yet. This is what happened. You know, this is the gist of it, essentially. Even though he didn't, he said so in so many words, right? And he said here that the court must not look at how Assange's health could worsen in the future. And this is what he called it, a crystal ball type of approach. I mean, come on, man. That's just disrespectful to anyone. Like, never mind Assange. You know, that's just disrespectful to anyone who's sick, right? Whether, I don't know, you have diabetes or mental illness, whatever it is, you know, like, what does that mean, a crystal ball type approach? When you see someone has an illness, you work on preventing it, on mitigating it, on helping their condition. You don't just say, oh, well, let's not think about the future. That's a crystal ball type approach. What? What the fuck does that even mean? So afterwards, he refers to Lori Love. Lori Love was outside the court today. I'll play you a clip of him afterwards. His extradition was blocked. The US also wanted to extradite him from the UK to the US. That was blocked. As a matter of fact, one of the judges today had something to do with the case. I'll get to that afterwards as well. But Lewis refers to the case of Lori Love, and he says that Lori Love's case was different because it was both mental and physical. And he says that the Turner criteria was not referred to. Now, the thing is with Lori Love, if I'm not mistaken, he also had Asperger's and Gary McKinnon as well. But I mean, Gary McKinnon, I think he exhausted all options. So Theresa May ended up blocking his extradition. She withdrew it, which good. I mean, it's surprising, but that's good. But I mean, once again, I really don't see how Assange does not meet Section 91. I really don't, and neither do the medical experts. But this is what he's saying, Lewis. And he's saying Assange's current mental state is not such as to preclude extradition. He has no history of serious mental illness. The court did not rule that care from the US is insufficient for any future illness Assange might experience. Yes, perhaps the court didn't explicitly rule that, although I have my doubts. I'll have to double check. But most certainly, many of the expert witnesses told the court that, you know, the prison conditions in the US are horrible. And I'm pretty sure the judge knows that. So that includes care for mental health, right? It's not just putting a healthy individual in terrible conditions. It's especially if, you know, you need medical attention, it's also bad. You will not get that medical attention. And this was made clear by the expert witnesses. And that's what Lewis is saying, though. That's what the prosecution is saying. And then he goes on to say, no one ever extradited from the United Kingdom to America has ever committed suicide. Okay, well, I mean, I don't understand his point again. Is he trying to break a record here? Good, I guess, but, you know, what are you trying to do? Are you trying to push Assange to be the first? Like, this is such a ludicrous, it's really a ludicrous thing to say. It's so dismissive of the science, of, medical science, psychiatry. It's just, so he then says that Assange's risk of suicide is a trump card. He said, if he's clever enough, he can get around the extradition. It then becomes a trump card, which cannot be dealt with by the requesting state, no matter if the prevention matters are 100 times better than in England. He said that Baretzer's decision, sorry, I've lost my place now because it's reloaded. He said that Baretzer's decision carries with it the risk of rewarding fugitives for their flight. So again, this is incredibly ignorant of mental health, of any medical situation. He's basically saying that, well, anyone can pretend to have mental illness and then be blocked from an extradition. Yeah, but no one is pretending. You have some of the best neuropsychiatrists in the world, literally, coming and testifying on Assange's behalf. So I don't understand what, who's malingering here. It's really, I don't know what to say except insulting. It's really insulting and wrong. So Lewis goes on to, he insists then that it can then never be said that a person accused of crimes similar to Assange's can be put on trial simply because the defendant might commit suicide. Rather, reasonable care could be provided to him regardless of the defendant's determination to commit suicide. He could still be put on trial. Nor would it prevent a court from remanding an individual in custody or imposing a custodial sentence in particular. So that's his opinion, right? He's saying that, claiming a defendant is suicidal, this is unacceptable because then everyone is going to use that. He then refers to the Turner test or Turner criteria, and he says that the Turner test requires the court to find a mental condition as such that it removes the capacity to resist impulse to commit suicide. And so, that, in other words, that means the defendant or the person in question cannot help themselves. They have an impulse, they have an urge to commit suicide, and they cannot fight it. It's inevitable. It's uncontrollable. And he says that Assange does not meet this criteria. Why? Because out of the 5 psychiatrists in this case, only one of them says that, and that's Koppelman. Well, that's still one of them. So he does meet the criteria. If one of the psychiatrists says he meets it, then he meets it. Just because 4 others disagree doesn't mean that it's necessarily wrong. But, that's not the same thing. If he said most of the psychiatrists don't think he meets it, okay, but saying that he doesn't meet it because only one psychiatrist said that, no. That's what he's implying in any case, right? That's what he's implying. And he goes on to say here that it's only Professor Koppelman who says that in his report, none of the others. Out of the 5 professional psychiatrists, only one of them says he has Asperger's, which is Dr. Deely. The other 4 say he doesn't have Asperger's. Okay? So do you see what's going on here? What's happening right now, or what was happening earlier today, but what's happening right now in the proceedings, the prosecution is trying to discredit the medical diagnosis, okay, on multiple fronts. So they're saying that Assange has no history of mental illness. Not true. They're saying that he doesn't meet the Turner criteria, meaning that Assange can control his impulse to commit suicide. Basically, that's what they're saying, that he's not impulsive. It's not going to overcome him. And then they're saying that the Asperger's, the autism diagnosis is false as well. Again, this is misleading the court because the doctor who diagnosed Assange with Asperger's, Dr. Deely, is one of the world-leading doctors in this field. So I don't know who you need more than him to make the diagnosis valid. Not to mention that out of the 5, so we have Dr. Deely who made the diagnosis, 2 of them said that Assange has autism-like traits, and the other 2 said that they don't agree with any of this. So, one of them diagnosed him with it, 2 of them say he has traits of it, and 2 say he doesn't have it at all. So, nevertheless, the prosecution is still trying to dismantle the diagnosis. Why is this diagnosis important? Why are they trying to say that Assange does not have Asperger's, he doesn't have autism? Because in combination with depression, if you have autism as well, the risk of suicide increases. That's what the doctors told the court last year, okay? So by saying, Assange doesn't have Asperger's, he's not autistic, he doesn't have autism, what they're trying to say is that the risk of suicide is low. That's what they're trying to get at here. Right, so I broke this down actually over here. I broke all this down, and everything I just told you basically is written down here. Okay, there you go. Feazell and Koppelman both said Assange's autistic-like traits. Okay, and then the court came back after lunch. Now here we got to the point of why the United States didn't provide these assurances earlier. Okay, so the prosecution argued that they may be offered at any point, including the appeals process. So this is funny. This is funny because one of the points, point E, is that Assange can serve his sentence in Australia and that he won't be placed under SAMS and he won't be sent to ADX Florence. These are the diplomatic assurances, right? And the prosecution are saying, well, we didn't give you these assurances before because they're not fresh evidence. We can give them at any time. Now, I think some legal experts might dispute that. I'm not a legal expert per se on fresh evidence in an appeals process, but Alexander Mercouris from Consortium News is a legal expert, and according to him, this counts as fresh evidence. So he said it would be interesting to see how it plays in court. Now, the prosecution argued it's not fresh evidence, and they said that they have the right to introduce this at any time. Okay. Here's the contradiction. Because then the prosecution say, well, the judge should have told us, Judge Brescher should have informed us that she wants to bar the extradition on health grounds, because then we could have given her the insurances. Okay, but if you're saying you can give them at any time, including the appeals process, why didn't you give them in the first place? So this shows you that there's a huge contradiction here, right? They lost the case. This is a fact. The United States lost the extradition case in January. And now they're sore losers. They're saying, well, the judge should have, made this position clear so we could offer her the assurances. But then at the same time, they're saying, well, we can give the assurances at any time. Great. Why didn't you in October 2020 then? Do you know what their answer is? They say, well, we don't think there's a high risk of Assange being sent to ADX Florence or placed under SAMS in the first place. Again, with the contradictions. They say that there's they don't think it's probable that he'll be placed under SAMS under these draconian prison conditions, and yet we look at the statements from Kronberg, from the federal prosecutor, and he's basically saying they will place Assange under SAMS. And as I told you, just before the lunch break, they were saying if Assange threatens national security, whatever that means, that's so abstract, right? They have the right to put him under SAMS again. Just rife with contradictions. It's unbelievable. So afterwards, what the prosecution started doing is basically addressing the lengthy prison sentence. As you know, Assange is charged with 17 counts under the Espionage Act, one more count for conspiracy to commit computer hacking. In total, that adds up to 175 years. Even if Assange is convicted on 2 or 3 counts, that's maybe 20, 30 years. Add that to his current age, 50. That's a life sentence, basically. He'll be in there until he's 80 or 90. It's like a life sentence. They don't even need to convict him on all counts. But what the prosecution started doing is trying to downplay the fears of a lengthy sentence. You know what they started doing? They started giving other examples of people who were sentenced for the same crimes under the Espionage Act, or similar crimes under the Espionage Act, and saying that the expected sentence was much longer, and in the end they got so-and-so. Who did they use as an example? Daniel Hale. So as you remember a few months ago, the drone whistleblower Daniel Hale, he exposed the United States drone program, how it was killing civilians more than anyone else, and how the Obama administration was covering this up. So Daniel Hale, look what they said about him. They say he is guilty of stealing information classified top secret, but in fact the court only imposed 45 months. Yes, but that's because the judge, if I recall well, threw out multiple counts with prejudice and toned it down. So, Kevin Costola did great coverage of this, of course. And, of course, John Kariaki was talking about this, too. And he said that basically Daniel got a lucky judge compared to him. So that's one factor. But nevertheless, I'll just give you the examples of what the prosecution was saying. They used him as an example. And then Lewis said, one has to be very careful how these sentences are arrived at. The longest sentence ever was Reality Winner. Only got 63 months. So they're trying to downplay the lengthy prison sentence. But once again, I reiterate, none of these people are Julian Assange. They really have it in for Julian Assange. I don't think you can compare that. And even if we look at this and you say, oh, well, Reality Winner got 63 months, Daniel Hale got 45 months, that's nothing. Who said that's nothing? Why should, we're talking about whistleblowers and journalists. So this idea that, oh, don't worry, this, Julian Assange won't get a long sentence. Why should he get any sentence? He's a journalist. He's not a terrorist. This is what they're doing. They're equating whistleblowers, journalists with terrorists. This is what's happening. And as I mentioned, at this age, at 50 years old, even 2-3 counts is like a life sentence. This is a real problem. And then Lewis goes back to the medical, assessment by Professor Koppelman. What does he say? He says that Koppelman's psychiatric report was contingent on the self-reporting of Mr. Assange. Yeah, so is literally every psychiatric report in the world. Every psychologist and psychiatrist relies on the self-reporting of who? The patient, to make a psychiatric evaluation. What is so strange about it? Of course, who else would know better than Assange about how he is feeling and what he's going through? This is ridiculous. The whole science of psychiatry relies in large part on self-reporting. So I don't understand what his point is here. This is absurd, right? So what does he add to that? He says one of the differences in Koppelman's approach and that of Blackwood and Feazell, who were called by the prosecution. These are the medical experts called by the prosecution. He says the difference between Koppelman and Blackwood and Feazell is that they considered the day-to-day notes and observations made by the clinical staff and other staff of Belmarsh. Once again, this is misleading the court. Why? Because this was addressed last year. Julian Assange is locked up in a prison, in the worst prison in England. If he tells the prison staff, including the prison doctor, I'm feeling such and such, I'm feeling suicidal, he risks being put in even more oppressive conditions. The medical experts who testified at Assange's hearing told the judge, they told the court, it's normal. It happens very often that prisoners don't reveal the full extent of their medical condition to, or they're rather specifically regarding mental health, to prison staff for fear of retribution or for fear of being put in solitary confinement. Who knows? For fear of repercussions. So there's nothing weird about that. And I would argue, and I think, this is not just confined to prison. Even at work, in general, in society, there's a large stigma around mental health, which really sucks, right? So it's not just a prison thing. In general, people are afraid to talk about this for fear of repercussions. And it shouldn't be like that. But unfortunately, there is a stigma. So I don't see why he's pointing this out. Of course, if you look at the prison notes, as he said, the day-to-day notes and observations made by the clinical staff at Belmarsh, of course you're not going to find the truth about how Assange feels. Of course, he did not confide in the prison staff the same way he confided in Koppelman. I mean, this is logical. And this was explained during the extradition hearing last year. Not to mention that one thing they leave out is that Koppelman spent the most time with Assange, more than anyone, more than the prison staff, more than Blackwood and Feazell. So his psychiatric evaluation is based on, it has more weight, just logically speaking. But Lewis goes on to say that he does not support Koppelman's findings. He says that the findings of Blackwood and Feazell do not support Koppelman's findings, right? He says there's a very obvious need for caution and scrutiny when it comes to Mr. Assange's own reports and health and diagnoses based on that. Lewis said that because Assange had every reason to exaggerate his symptoms, Assange had asked to see his legal team before being assessed at Belmarsh Prison. He was reading the British Medical Journal. What is that? This is where we get to one of the most ridiculous things I've ever heard. And this was not just today. This was last year as well. The U.S. prosecution, Lewis here, is saying that Assange cannot be trusted. You can't trust his self-reporting on his own mental health. Why? Because he was reading the British Medical Journal. What does that even mean? Like, he read something about mental health in the British Medical Journal and then pretended to have that? That's what he's implying. And even he knows it's bullshit. He says, one can't necessarily read into that, but it's a factor. What? This is the absurdity. This is what we're dealing in. This is what the whole case is hinging on right now. Can you imagine this? And then the worst one, I mean, this is just crazy. He brought up milk and orange. No, what was it again? Milk and oranges. Yeah. milk and oranges. He said that Assange had requested milk and oranges, and I think it was he played pool or something. So this clearly shows he's not suffering from mental illness. Oh my God. What does that mean? Does that mean anyone who has depression or psychosis, whatever it is, does not consume milk and oranges? What does that have to do with anything? Keep in mind, no, this is Lewis saying that, the lawyer for the United States. It's not from a medical expert or something. It's just him saying. Oh my God. It's so ridiculous. It really is. Milk and oranges. So he's citing these things to show that Assange is a malingerer, to accuse Assange basically of lying, right? He says that we must take into account the extraordinary lengths that Assange went to avoid extradition to the US. Within a few days of losing his case at the Supreme Court, he entered the Ecuadorian embassy and stayed there for 7 years, and only left when forced by the Metropolitan Police, the London Police. Lewis says that during those years, Assange was very, this was an inaudible part, but, he basically sought protection by Ecuador. He says that Assange hosted a chat show on Russian TV on RT and assisted Edward Snowden on his flight to the US. I mean, I don't know how these things preclude Assange from having mental illness. I'm pretty sure this was mentioned by the medical experts. There's a thing called functioning depression. I'm speechless. Really, I'm speechless. Like this is his evidence that Assange is in good health. Then he says that. Sorry, just lost my spot for a second. Oh yeah, you can see my reaction to the milk and oranges here. Oh man. So just let me find my place again. Yeah. So Lewis says that Koppelman was misleading to that position, and again that Assange has no former psychiatric history, but he contradicts himself because he said that Assange was admitted to a psych hospital for a few days, just for a few days during his 20s, and that he had no diagnosis of autism until he was in Belmarsh. Lewis says he makes those forensic points because if there were ever a case which required a dispassionate, objective searching, but above all an expert opinion, it's this one. And then Lewis says that, I'll just add one note over here. Which I think is important. He says that Assange was not diagnosed with autism until in Belmarsh. Well, the onset of psychological and physical illness can certainly trigger or bring out something that was perhaps dormant. Again, I'm not talking specifically about autism, but I don't see how that excludes or negates everything the medical experts said. I think this was most certainly brought up and responded to by the expert witnesses. So again, these are points that that Lewis is trying to resuscitate, trying to revive from last year and use them again against Koppelman. He's basically redoing the whole case. Like all of these arguments, I heard them last year, right? So he's going through the whole thing again. He's basically re-arguing the whole case here, or most of them, in any case. He says that Koppelman based his opinions on those close to Assange, like his father, and that when Koppelman knew full well that Assange hadn't I think it was a typo here, right? Had in those years a relationship with Miss Morris, including 2 young children conceived in the embassy, that he hid this, right? He then points to something which was in the ruling. So Judge Baretzer, she quoted this in the ruling in January, right? And I'll find you the quote in just a second. There we go. That's the quote. That's what I'm looking for. So Lewis, the prosecution, refers to this quote from Assange. Assange told his psychiatrist Koppelman, the only thing stopping me from suicide were the small chances of success in the case, the legal case, and an obligation to his children. Okay, and so what does Lewis do? He says, well, clearly, Julian Assange cannot be suicidal because he said that the fact he has children stops him from wanting to commit suicide. I mean, talk about someone who doesn't want to who doesn't want to do a crystal ball approach. He's certainly doing one there, right? What's to say that upon extradition, the conditions, the mental conditions would not change? They most certainly would, right? So these are the things that we're listening to in court. You know, this is what's happening. So once again, we have more stuff about the relationship. Okay, Lewis refers to Koppelman acknowledging his duty to the court as an expert witness, and that he was aware of Criminal Procedure Rule 19. He says he should have been aware that he could have made an application, but did not do so. Okay, so Criminal Procedure Rule 19. This is basically regarding. This pertains to expert evidence. Okay, so he's saying that if Koppelman wanted to conceal, okay, if he did not want to reveal the information about the relationship, he should have made an application, right? So this is an application you make if you want to, if I'm not mistaken, pertaining, hold on, I'm trying to switch back to my camera. Here I am. So this is an application that you would make if you wanted to withhold information that is perhaps not relevant, or, you know, is for the sake of privacy. And so the prosecution is saying, well, Professor Koppelman, he knows about this. He knows that he has to tell the truth to the court. He knows that he has the option to file an application with Criminal Procedure Rule 19, and he didn't do so. So therefore, he's dishonest. This is the argument. Okay? And again, this is only pertaining not to any medical information. It's only pertaining to the psychiatric evaluation. So he's saying that, you know, since the report relies on people close to Assange, and he did not reveal who the partner is, that it's Stella Moores, that he's dishonest, and the psychiatric evaluation cannot be trusted. And therefore, Assange is not suicidal, and therefore we can extradite him. This is the whole line of thinking. So he goes back here. He says this was not an honest statement of truth from Koppelman, and the judge erred in not taking this into account. Again, this is incorrect. This is simply incorrect because the judge did take this into account. I even posted the screenshot below from the ruling, and you can see what Judge Barretza said. Quote, in my judgment, Professor Koppelman's decision to conceal the relationship between Julian Assange and Stella Moores was misleading and inappropriate in the context of his obligations to the court, but an understandable human response to Miss Morris's predicament. He explained that her relationship with Mr. Assange was not yet in the public domain, and she was very concerned about her privacy. After their relationship became public, he had disclosed it in his August 2020 report. In fact, the court had become aware of the true position in April 2020 before it had reached the medical evidence, before it had read the medical evidence or heard evidence on this issue, which is correct because, the extradition hearing began in September, but of course we had proceedings beforehand, but, due to the pandemic, they were postponed for a bit. But the medical part of the medical testimonies, it was about 3 days, I think, of medical testimonies in the extradition hearing. This was, in September. Right? So it wasn't well after we'd heard the arguments about the First Amendment, about journalism, and so on. So the point here is that Professor Koppelman didn't really lie to the court. He did make it clear to the court, that Assange and Morris had a relationship before the court even heard any medical testimony. So this is such a technicality of a technicality on which the U.S. prosecution are trying to screw Assange. It's really utterly obscene, So when Lewis says that the judge didn't take this into consideration, she did. She literally addresses this in the ruling. She says she knows it's inappropriate, but it was an appropriate human response. And I would add, and I think anyone, any reasonable person would add, it's not just about, the privacy issue with the press, which is already bad enough. The CIA are trying to kill this man. What more do you need? They wanted to kidnap a diaper from the children to find out who's the real father. Like, what more do you need, man? What's the threshold for you? At what point, like... Anyway, I'm just reporting to you what happened right now. Let's continue. So, Assange at this point, he got up. We couldn't see him anymore, but I saw his reflection in the glass on the door, so I figured it was him. But he just changed position in the room. He just moved to another chair. But he was in and out, sometimes. So the lawyers told the court he's not feeling tip-top. He's not feeling too well, which is, completely understandable. And of course, he was just moving in the room and coming in and out sometimes. So Lewis then goes to Dr. Blackwood. So Dr. Blackwood, he was called by the prosecution last year. Just to remind you, during the extradition hearing, as I said, we had 3 days, I think it was a couple of days of medical testimony. During this time, there were 5 psychiatrists who were called, right? Was it? And 3 of them by the defense and 2 by the prosecution. The ones called by the prosecution, Feazell and Blackwood. And then for the defense, this was Koppelman, Dealey, and I think it was Cosby, right? And so what Lewis starts doing, he takes the transcript. I mean, he was doing that just now with Koppelman's cross-examination. Now he goes to the cross-examination with Blackwood, which he called to the witness stand. And he refers to Blackwood's assessment of Julian Assange's health. Now, Dr. Blackwood says that Assange is not at high risk of suicide. He says that it's manageable, right? He says that the risk of suicide is manageable and that Assange has the capacity to resist. And again, if I may just quickly interject, and I think, the defense witnesses also made this clear, is that this can change. This can change, and it's easy to say that it's manageable, but when you're extradited, that could change, could it not? But another important point that Lewis wants to make is that the risk of suicide is not high. So he refers to Feazell, who's the other medical expert called by the prosecution. What does Feazell say? Feazell says that a high risk of suicide for him means that it's high compared to other prisoners. So he's saying you have to have a comparative group. You have to put Assange in jail, and then, figuratively, and compare his suicide risk to the suicide risk of other prisoners of the same gender and the same age group. That's his approach, and that's what the prosecution refers to again. Right? So they say Assange is not at high risk of suicide, right? And then they were talking about how, the rates are slightly better in the US and comparing them to Wales and England. Lewis, again, he goes to the transcript and he talks about Koppelman, and he starts chipping away at his credibility, starts chipping away at the medical evidence. This is what was going on for the better part of an hour, right? So you have the prosecution attacking Professor Koppelman, key medical witness for Assange, saying that he can't be trusted because he did not disclose the relationship with Stella Morris, saying that his medical expertise is incorrect. And how did they explain this? Lewis, he starts reading from the cross-examination from last September, and he says, he starts reading this part where he asked Koppelman about the Diagnostic and Statistics Manual, the DSM, which is used for psychiatry, mental health, and the ICD codes, so the International Classification of Diseases. I have them over here. So back then, he asked Koppelman about, I think it was ICD-10, that was the code. So, in medicine, these codes refer to an illness. So, ICD-10 refers to whatever. I'm just going to give an example. It's totally incorrect. Diabetes, for example, and so on. Okay? But these are mostly pertaining to mental illness in this case, of course. And so it was kind of like a stupid trick question. I mean, this guy's one of the best neuropsychiatrists, and he's asking him about some ICD code. a stupid trick question. And what did Koppelman tell him? He told Lewis, I don't care. I don't like those bloody books. I think that was the quote. I don't like those bloody books. And he said that he prefers to do his own approach. And again, you must remember, he's an emeritus professor at King's College, right? He's one of the world's top neuropsychiatrists. So you're not dealing with an idiot here. He just has a different approach. And Lewis tries to make it look like he's an idiot, and he's not up to standard, and so on. And what is so ironic about this, and this was said at the time of the court, Lewis himself had used Koppelman as an expert witness in another case. And Koppelman said this, well, you're questioning my expertise now. Didn't you call me to help you in another case? So when it suits him, he's a good expert witness on psychiatry. And when it doesn't suit him, he's an idiot. He's unqualified. It's extraordinary. The whole court was laughing when he said that. So this was the part again about milk and oranges, which is ridiculous. I'm just going to go past it. And then, of course, Lewis starts referring to Nils Melzer. And Nils Melzer, had him on the show before. He's really great. He's the UN Special Rapporteur on Torture, right? So he visited Julian Assange in Belmarsh prison with 2 physicians, if I recall well. And he issued a report saying that Assange is being effectively tortured. This is psychological torture, the conditions he's being kept in. And he said that it's a political witch hunt. And here we have, once again, what we heard last year. What does Lewis say? First of all, he says Nils Melzer is basically biased because he criticized how the UK judges are handling the case. And then he says Koppelman cherry-picked parts of Nils Melzer's report. So I'm going to pull this up for you, the report. We've covered it before, but I'm still going to pull it up nonetheless so you can see it on the screen. Okay? So this is from May 2019. And you can see here the report from Nils Melzer, okay? And here he talks about, for example, there's been a relentless and unrestrained campaign of public mobbing, intimidation, defamation against Mr. Assange. But if we look, if you look at this part, he talks about extreme stress, chronic anxiety, intense psychological trauma. So what did Koppelman do? Because again, he's a medical expert witness. He took this part that talks about psychological trauma. And then the US lawyers are accusing him now of cherry picking. Of course he's cherry picking because the other parts are not relevant to the medical testimony. This is so crazy. This is the type of stuff we're listening to, So last year they were saying that this report from Nils Melzer is unacceptable because it's political, right? He talks about Mr. Assange being defamed and mobbed, which is true, and that they don't accept that Koppelman is citing it, basically, because they find it too politicized. And then at the same time, they're saying, oh, but you cherry-picked it. Yeah, he left out the political parts. He only wanted the medical ones because Nils Melzer visited Assange with 2 doctors, so the medical parts are relevant. This is the kind of stuff the prosecution are doing, So they took a jab at this, and then they went back to Dealey, right? So as we said, Dr. Dealey is the other expert, a medical expert. He diagnosed Julian Assange with Asperger's, okay, so on the autism spectrum, and Lewis says that Dealey is the only doctor who diagnosed Assange with autism. 2 others said no autism, and 2 others indicated presence of autistic traits. Okay, and his point here is that the autism diagnosis cannot be trusted. That's his point. So he starts challenging the autism, the Asperger's diagnosis, and saying that it's just one doctor, therefore it doesn't amount to much. And the whole point of that, as I explained to you, is trying to minimize the suicide risk, to say that it's to imply that it's not as high. So then, in general, Lewis starts complaining about Professor Koppelman's medical testimony being taken into account by Judge Boretzer because she relied on it the most. And he says there's a real divergence of psychiatric evidence. Okay? He says that it wasn't sufficient for Barretzer to simply say that she prefers Koppelman's psychiatric evaluation without giving cogent and detailed reason as to why. She did. She did, though. And then he says that Barretzer doesn't deal in any way with the weight which should be attached or not attached regarding Koppelman misleading the court. Again, this is a lie because she did. As I just showed you, it says it right here. There it is. An understandable human response. So, he's making points that are just simply untrue. All of these things the judge did deal with. She explained why she preferred Koppelman's testimony. She explained what she thought of his, non-disclosure of the relationship. And then he asked, what is an understandable human response? What does this mean? An expert has a duty to the court. The judge then asked a question. The judge asked the prosecution if they're seeking to exclude Koppelman's report on admissibility or to dispute its weight. So if we go back to the grounds of appeal that are at the top here, one of the reasons that the United States is appealing extradition, what do they say? They say that this is point C. Koppelman's medical testimony should either be excluded, it's inadmissible, or it could be said that his lack of independence went to weight. Okay, so she should have attributed no or far less weight to his opinion. So basically, they're saying that either the medical testimony should be completely removed or given far less weight. That's their opinion, and the judge wanted clarification what they're trying to do, because this was the whole point. You won the right to appeal this. What are you trying to seek from it? And the prosecution said they don't want to exclude Koppelman's testimony. Okay, so even though they've had it up to here with him for made up reasons and whatnot, they still don't want to exclude Koppelman's testimony. They just want the courts to give it less weight. That's what they're seeking here. Okay, and of course we'll see what's decided. But as I said here, Twitter was messing up my thread. This is the conclusion. So we're getting to the conclusion from the prosecution here, okay? So I'm just going to go through this quickly. So the prosecution says that the overall evaluation of the evidence goes to particular issues like the future risk of suicide. And then they said you can't look into the future to predict suicide. Lewis then says that Fazel's opinion about high risk of suicide means there's an elevated risk of suicide in comparison to the other ordinary members of the prison population, right? So this is about comparing Assange's risk of suicide to the other prisoners. So he thinks that should be the criteria. And then they talk about, judging suicide risk on a long-term basis. They say that they can't do it, but even if they did, the US has better or lower rates of suicide. And then they say that the judge erred in her ruling because she posed the question of whether Assange's intent to commit suicide comes from a psychiatric condition, and that this is not a proper test. It should be whether the individual is sufficiently mentally ill that he has no ability to resist suicide. That is the correct formulation. And so we'll get back to this. I'll tell you what the defense responded to that, because this is a very important point. And then regarding Section 91, which allows you to block an extradition under the Extradition Act, the prosecution says that Assange's mental condition must be such that it removes the capacity to resist the impulse to commit suicide, and that Fazel and Blackwood did not find the case. Okay, again, that's not what it says on Section 91, but okay. And then the prosecution said that the appeal should be allowed because the assurances that they will not put Assange under SAMS, they will not put him in ADX Florence, he can go serve in Australia, exclude the factors which the defense's case depend on, right? So that's what we talked about, that they think that, okay, well, if we promise to treat Assange nicely, then the whole medical evidence collapses. That's not true. Second point is that given these assurances, it cannot now be said that it's oppressive to extradite Assange. The judge would have decided the question differently under Section 91. Right? So this is the big point they're saying. They're saying that if the judge had been aware of our assurances that, there will be no SAMS, he can go to Australia to serve the jail sentence there, she would have ruled differently. So they're saying that she made a mistake because, they weren't afforded the opportunity to give her these assurances, and that if she had known about these assurances, she would have made a different decision. That's their argument. And then regarding Section 91, the approach, so the threshold, right? they're saying the judge is wrong because she based it on a future prediction. She should have based it on Assange's current mental state. Is Assange depressed right now to the point that he's going to kill himself? He can't control it? If yes, then he meets Section 91. But to look into the future, the crystal ball approach, as the prosecution call it, they're saying this is wrong. The judge should not have considered if in the United States he will commit suicide, because this is predicting the future. I'm just telling you what they said. Again, he says she applied the test incorrectly. Had she decided it about his current state, she would have arrived at a different conclusion. Point 4, the prosecution say the judge failed to take into account relevant facts of consideration to those future events, right? There's a possibility Assange could maybe have the time he spent in English jail taken out of his sentence in America, serving less time. So, this is, again, insane. They refer to another case where someone was extradited from the UK to the US, and they had served many years in English jails, and I think it was a 20-year sentence, and the judge in the US deducted those years from his sentence because he had served them in the UK. Okay, well, I mean, if that's your argument, what does that leave Assange with? 165 years maybe in jail? Like, what? Why should he be one day in jail? This is still a violation of press freedoms, right? It's like we're not even dealing with that anymore. Insane. So I'm gonna just finish this up for you. But this is the point that they're making. This is the point that they're making, that, if you're going to look into the future, well, you should have considered these things. Lewis says it's intangible to try and grapple with potential future events. Koppelman's evidence was inadmissible and should have been given no or considerably far less weight. He says it lacked expert evidence, failed to comply with standards, and lacked a core statement of truth, right? So he maintains when you don't see evidence as a whole, it's difficult to determine the overall reliability of opinions. So he's saying that Bretzer relied too much on Koppelman's opinion. She did not take the evidence of Feazell, Blackwood, and the other expert witnesses into account. Again, this is not true. She explains why. And then Lewis says that as a whole, Bretzer should have weighed crucial factors significantly differently. Therefore, District Court Judge Bretzer was wrong in answering the question on Assange's capacity to resist suicide. And now we have the defense that took over. The defense only had 30 minutes because, tomorrow the defense will have all day. They'll have the time that the prosecution were allocated today. So tomorrow the defense will respond to all these points in full. But nevertheless, they had about 20-30 minutes. And, I mean, Fitzgerald, one of the first things he says, absolute nonsense. It's true. It is absolute nonsense. And they went point by point as fast as you can and said that, look, at the end of the day, the judge, she had all this evidence before her. Whether it's Feazell's medical, expertise, or it's Blackwood's, or whether it's Koppelman refusing to disclose Assange's relationship with Stella Morris. The judge knew this. She knew all of this, and she still decided against extradition. So the judge did not make a mistake, right? This is their point. They say the district judge was perfectly correct in reaching those conclusions before, okay? Views of Koppelman, Dealey, and want us to recall that Feazell said he did not dispute the correctness of Koppelman's findings that depression was severe. So even though the other expert witnesses called by the prosecution perhaps don't agree to which degree Assange is suicidal, right? Some of them say it's a high risk of suicide. Some say it's manageable. They still agree there's a risk of suicide, all of them. Okay? That's important to note. Fitzgerald says, this picture that my friend tries to paint, that Professor Koppelman was some lone wolf, is absolute nonsense. Koppelman's medical testimony was supported by Dr. Dealey and in large part supported by Professor Feazell too. That's correct, right? The way that Mohammed Al-Mazi said this the best, right? So he said that they're trying to paint it as though Koppelman was crushed. It's not true. It's not true. I mean, last year, during his testimony, Koppelman was doing great. He was doing very good, right? So he was able to counter all of Lewis' points on cross-examination. It was very good. So the way that, they're making it seem today is just not true, because what Lewis was doing, what the U.S. prosecution was doing, just going through bits and pieces and making it look like they have such a solid case. But Fitzgerald goes on to say, though, that one of the prosecution's grounds for appeal is that the judge didn't address the capacity to resist suicide. Look at the heading. said Fitzgerald. It's true. There's literally an entire heading, the capacity to resist the impulse to suicide. But, you know, if you listen to the prosecution, they say the judge never addressed this. It's ridiculous. It's one of the headings in the table of contents. So, I mean, yeah, this is what was happening, you know? So the defense then said that it's not just about impulse. A person, so he gave the example of a woman for just as an example that, you know, if there's a woman who's you know, experiencing severe depression, or just anyone, you know, who's going through that, and they make plans to kill themselves, it's not impulsive, but it's still driven by a mental disorder, right? So this is very important because the prosecution are trying to say, look, Assange is not impulsive enough to be, you know, that we should block the extradition. He has no impulse, no great impulse, some uncontrollable impulse to commit suicide. Therefore, he's fit enough. We can extradite him. Yeah, but this is ridiculous. As Fitzgerald just says here, it's not just about impulse. You could not be impulsive and still make plans to commit suicide. You know, there are many people who've done that. So it's not a question of impulse. It's a question of, do you have the mental disorder? Is there a high risk? Yes. Right? So this was a very important point. He pointed to Dr. Blackwood, that he's the only person who said that depression wasn't severe in 2019. The other four agreed it is. Again, to various degrees, but nevertheless, it was severe. And he said, even if there are protective measures in the requesting states, so even if the United States promises to protect Julian Assange, okay, even if they promise to protect him, will that be enough? Or will the person commit suicide no matter the steps taken? That is the test. I think that's also reasonable, you know? So it's not just a question of, does the United States have adequate medical care for inmates in supermax prisons, you know, or in general? You know, does the United States take mental health seriously for inmates? Are the suicide rates lower? It's not just a question of that. Is the person facing extradition, is Julian Assange at high risk of suicide? Will he take his life no matter what? That's the test. Yeah, that is the test. Then he said to the prosecution, I wonder if you're reading the same judgment as we are. And I was also, I mean, I just laughed at that because it's true. You know, like everything they say the judge didn't address, she addressed. It's all here in the ruling. He says that the judge did deal with the points raised, contrary to what the prosecution claims. Right? And she did explain why she preferred Koppelman's medical testimony. The protective measures offered by the United States were already addressed. Everything is there, and the idea she ignored this is not true. And that was it. That was it for today. All right, so tomorrow, I'm not done, by the way. I'm just saying that that's what happened in the court. I'll show you some of the speeches as well and explain some other things. But that was it for today, right? So this was day one of the appeal. Tomorrow will be day two. I don't think it will go on to a third day. Who knows? But it's supposed to be just tomorrow, and tomorrow the defense will take their turn to address all these points. The first thing I want to say before I even address any of these things: do you see how messed up this whole situation is? The whole trial about Julian Assange has become his mental health. The entire focus now is Julian Assange's mental health. They're putting his mental health on trial. So, is this a violation of the First Amendment? Yes. Is it a violation of free speech? Yes. Is it an attack on journalists? Yes. Is this oppressive to you know, Julian Assange? Yes. Is this a danger to all journalists? Yes. And whistleblowers? Yes, absolutely. None of this is being addressed. None of this is being addressed. Where is Tony Blair? Where's Jack Straw? Blunkett? Dick Cheney, Paul Wolfowitz, where are these people? Why are they not in the dock right now? Why is it Assange? There's nothing anymore about how this is an attack on press freedoms. There's nothing anymore about how this violates every law you can think of, you know, in regards to free speech and journalistic endeavors. Nothing. It's all about Julian Assange's mental health. And even then they're trying to screw the entire case. They're trying to overturn the whole thing on a technicality. On a technicality. Look, man, Koppelman made 2 reports. In the second one, he did disclose the relationship because it was already public by then. The relationship does not change the veracity of his medical expertise. He's one of the world's most renowned neuropsychiatrists. He's not the only medical expert. There were others who verified Assange suffers from depression. There's a high risk of suicide. It's not just his testimony. This was corroborated by other medical experts. What does it have to do with his medical testimony? Nothing. They want to paint him as dishonest. They want to show that he has a lack of integrity, that he abdicated his duty to the court, right, as an expert witness, and that therefore his testimony has to be thrown out. Why? Because that's the only obstacle. That's the only thing blocking them from going forward with the extradition. It's the medical issues now. This whole case is not just about medical issues. It's an attack on press freedoms. It's wrong on so many levels. Again, I've gone through this a million times. But this is a violation of, Assange's right to due process under US law, under British common law, under EU law. It's a violation of his free speech rights. It's a violation of his... Again, by the way, there's no difference between, there's no clause under free speech for journalists. It applies to everyone. So people who say Assange is not a journalist, I don't give a shit what you think of him, whether you call him a plumber or a journalist. He has the right to publish those things, right? If he's gonna go to jail, what about the New York Times? What about the Guardian? I'm not saying they should go to jail too, but if you go after him, you have to go after everyone. There's so many things wrong with this case, and now we're discussing none of this. It's all out of the window, and it's only about the health. Now, whether we actually see these issues come up on cross-appeal, which would be great, I don't know yet. But they should. Because, what has happened in the last couple of days? We've had, in the last couple of weeks, we had basically Mike Pompeo admitting that this plan to potentially kidnap or assassinate Julian Assange is true. Mike Pompeo, he basically inadvertently confirmed its authenticity, because after Yahoo News talked to 30 U.S. officials about the CIA's considerations to maybe kidnap or kill Julian Assange in London, Mike Pompeo, the former director of the CIA, comes out and says these people should be prosecuted. Well, hold on. If this story is not true, why would you want to prosecute them for something that's not true? It's true. It's real. And by the way, there's something in the article that I don't think a lot of people address, which is that it doesn't even say that Mike Pompeo came up with this. It says it predates his arrival to the CIA. So they were discussing this before Mike Pompeo was even there, right? But my point here is that we have proof, not just from unnamed U.S. officials. You should never take that at face value. If it weren't for the UC Global employees who had testified in court in Spain, and I heard the testimony myself in London, the same employees who testified anonymously that there were plans to maybe kidnap and or assassinate him. If it weren't for their testimony as well, okay, but I mean, it's 30 people and we have their testimony. What more do you need? You saw the footage too. They were spying on him. So despite the fact that we have additional confirmation that the CIA wanted to maybe kill or kidnap him, where is this in court? If Koppelman refused to disclose the relationship between Assange and Stella Morris, can you blame him, given all this stuff that's going on? The CIA considering kidnapping or killing him? How could you blame him, man? Never mind the press, right? But that's one thing. And we saw also Torderson, so one of the key witnesses for the U.S. prosecution in regards to the supposed conspiracy to commit computer hacking and computer intrusion. He came out and admitted that he lied. His testimony is fake. So we have two extraordinary developments in the Assange case, and they're not being addressed in court. And I know today was not about those. I get it. There's a process. Today was about the medical, about the 5 grounds of appeal, rather, right? So the assurances and the medical testimony. Yes. And everything must be addressed in due course. But just, look at where we're at. I just want to give you, some commentary here, some common sense. Look at where this situation is right now. This is why it was so dangerous, this ruling in January. We were all happy, of course, when the judge said no, and the bail hearing was in 48 hours. So there was some hope. She might release Assange, There was some hope. Ultimately, she didn't. The same judge, she sent him back to Belmarsh on remand. And so it was good that she blocked the extradition, but she did it for the wrong reasons. And now we are seeing why. No more discussions about free speech. No more discussions about journalism. Never mind the people who committed these crimes. They're never facing justice. Like, they're not even, I haven't even heard George Bush's name at all. Like, not once in this whole thing, even though he started these wars. Not once. It just doesn't come up. It's just irrelevant, you know? Biggest war criminal in modern history. No doubt. The worst, most dangerous administration in modern history. Every administration since Obama, Trump, Biden is a continuation of Bush, right? Nothing. So they're persecuting the guy who exposed their crimes. The criminals walk free. The whole subject has shifted to Assange's mental health. And even then, they're trying to wear down the medical experts. They're trying to poke holes in the defense's case, which is already ironclad. Like, how many more doctors do you need to testify? Even the prosecution's own doctors are saying the guy has depression and a risk of suicide. They don't agree to the same degree, but they know it's there. And now they're trying to change the criteria. It's just insane. So I just want to play you some clips. This was Julian's father, John Shipton. He's lovely. He's great. I spoke to him before. It's on the channel if you want to go watch it. But he spoke outside the court. Take a look.
Can reassert today the Magna Carta, a shield between the state and the people. And again, we can face the prospect of justice in the law system.
Are you concerned the US could prevail today?
Sorry?
Are you concerned the US could still prevail?
Oh, well, we'll prevail. We don't give up.
So I don't know if you can hear clearly, but he says we don't give up. We don't give up. And there's some other clips as well I wanted to play you. So this is WikiLeaks editor-in-chief, Christina Nafson, also outside the High Court today. Here's what he said.
We just learned that Julian Assange will not be here in person today. He was denied that opportunity, which I think is outrageous. He is going to be up here via video link, but how can he interact with his lawyers from Belmarsh prison? How can this be justice in any form when he is deprived of being present here today, where his life is being decided? That is an outrage.
And this is Stella Morris, Julian Assange's partner, also outside the High Court today. Here's what she said.
What's at stake here isn't what is argued in court today. It's about whether the UK courts are going to extradite a journalist to the country that conspired to assassinate him. It is completely unthinkable that the UK courts could agree to that. I'm very concerned for Julian's health. I saw him on Saturday. He's very thin. And I hope that the courts will end this nightmare, that Julian is able to come home soon, and that wise heads prevail. We're very concerned that he's not able to be here, to be able to give instruction to his lawyers, to be able to ask for clarification about the goings-on in court.
Yeah, it's really messed up, man. You know, I'm not sure exactly why he was prevented from being there. My understanding was that it was due to health reasons. He's just feeling too unwell, which is, you know, given the circumstances, totally understandable and to be expected, no? And yet, if you listen to the prosecution, they say he's totally fine, right? Here's Lori Love outside the court, right? So I want to play you his clip.
The real reason Julian should not be extradited to the United States is because Julian Assange helped enable and facilitate the publication of journalistic evidence of war crimes by that same government and regime that this court now considers that he should be rendered unto to undoubtedly be tortured and made an example that nobody else in the press, nobody else like so many of you that I see standing before me today with cameras and notepapers and laptops, and presumably, if not today, at some point, the aspiration that you would stand up to power and speak truth to it in the interests of justice and democracy. Thank you. The real reason, Julian.
So, I mean, as you can see, just so many people coming out to show support for Assange. Here's Team Assange outside the court as well. Team Assange are the best. They're you couldn't wish for better activists. They're magnificent. So big up to them. Big up to everyone. Also everyone who's covering the case. I mean, just fantastic work. I saw Kevin Gostola give me a shout out on his channel. That was really nice of him. Hold on, I'll just play you this clip.
You really want to look for people who have been there.
So yeah, so I'll explain what Kevin's talking about. Today in the court. You had a bit more people than usual, and I think it was. So the idea is that it's probably because of the Yahoo News story, right? Because it got a lot of traction and attention. Finally, we knew it before, but this is confirmation again that the CIA was considering to either kidnap or potentially kidnap or kill Assange, and perhaps that's why a bit more people showed up. One of the authors of that story was there from Yahoo News, and Kevin was just saying, I think, to that it's good, but here's the clip.
You really want to look for people who have been there since the extradition hearing, and I think those who are tuning into this know who those people are. Those people are out there. They're Richard Medhurst, Mohammed Almazi.
So that was really kind of Kevin. Thank you so much, brother. And I really couldn't recommend Kevin enough. He's the best. You should go follow him as well. You can see on the screen his Twitter. It's @KGostola. Let me just pull it up for you.
You really want to...
There it is. Go follow him. He's also doing amazing coverage. And he mentions also Hamed Almazi, also excellent. There's also Consortium News. There's Mary Kostakidis, Stefania Morizzi, Juan Passarelli. Really, so many. There's too many to mention, but they're all doing amazing work. And sorry if I forgot anyone, but that's really sweet of Kevin. So, yeah, just shout out to everyone who's covering this. And, we're not many, but we're I think this is really the most important case of our time. And so, what happens tomorrow? I don't know. I'm really hoping that the defense. I'm sure they'll kick ass. I'm certain, but I'm hoping that the judges will see things the right way. And this is what I wanted to get to. I think it was Consortium News who did some stuff on this about the judges. Some information that I wanted to tell you about before, right? About who was presiding over this today at the High Court. So. Take a look at this, okay? So the headline reads, Assange to get same judge who sided with the US on appeal over medical issues. So the same judge that overturned an earlier High Court decision to exclude Assange's health from the US appeal will preside over the substantive appeal hearing next week. That's Holroyd, right? Lord Justice Holroyd. So, Holroyd... Let me explain who Holroyd is. I just did in this sentence, but do you remember that basically on July 7th, was it? We had confirmation that the US would appeal on 3 out of 5 grounds, and then they went to court on August 11th, and then they got the 5 out of 5. And Holroyd was presiding over that when the U.S. got that victory on August 12th, right? And so that's something that's unusual, right? Usually you wouldn't have someone from an earlier step in the court case coming back for that, right? But Alexander over at Consortium News, I think he said that everything is proceeding the way it shouldn't proceed with this, right? It's a highly unusual case, it really is. But nevertheless, I think, if I'm not mistaken, Burnett was the other one today. I'm just going to double check on that before I say anything. But yeah, I mean, it's good seeing Reporters Without Borders that they were able to get in. It's good seeing them, the NGOs able to observe the case, but I wish the access would be easier for them, because it shouldn't be this difficult. Rebecca Vincent was talking about this, how difficult it is. It shouldn't be like that. I spoke to her in London about how it was in other countries with Reporters Without Borders, and yeah, it wasn't. I'm just, hold on, I want to tell you something. So there's a journalist who tried to get into the court. His name is Marcus, and I think he was reporting for Günther Wallraff via link and live stream in laptop on a trash can. So he was basically reporting outside from a trash can, on top of a trash can, because he couldn't get in at first. He did get in afterwards, though. But okay, that's just give me a second over here. Yeah, so just going back to the judges, it was indeed Burnett and Holroyd. I just wanted to double check before I said anything. So, Lord Chief Justice Burnett, he actually presided over the Lori Love case, which is very interesting, right? Because we were just talking about Lori Love. Lori Love is, of course, someone else who faced an extradition battle with the United States, and thankfully, it didn't work. The U.S. was not able to extradite him, thankfully. But yeah, the same. So he presided over that case as well, and he was present there today. And it's interesting because in the court, Lori Love was brought up multiple times, right? Anyway, just some little background information I wanted to give you. But nevertheless, tomorrow we'll be continuing. And as you can see, I'm quite exhausted. I've been, sitting here for like over 12 hours. I need to get some rest for tomorrow so we can continue. Let me just show you the thread again. So, tomorrow, come here at 10:30 a.m. GMT, or rather GMT +1, right? British Summer Time. So come here at 10:30 a.m. London time, and I'll be covering the extradition hearing. So, rather the appeal at the High Court for the extradition, day 2. Okay? So, that's the handle, at RichimedHurst, at Richie Medhurst. So, yeah, there'll be a live thread just like today. Okay? And I just want to say thank you to everyone else who's covering it, and thank you to everyone who's supporting independent journalism. It's a lot of work, but, it's our passion as well. So, yeah. If you guys have any questions, shoot, go ahead. And I'm just going to ramble on. If I have comments coming back or coming to mind, I will of course say them. But yeah, it's been, I think, about 15 hours now that I've been sitting here, so we're tired. But yeah, just give me a second. You guys are very kind. I see comments here from The Collective. Thank you very much. Michelle is also saying thank you. Thank you, Michelle. I appreciate that very much. And you guys are great. Vero says, get some rest, Richie. Great reporting. Merci. Enfin, je sais rien. What I say. But yeah, I don't know. I guess I guess I'm going to leave it there, but we have some tips over here on Rockfin, so thank you very much for that. Sora says, hold on, I'm going to scroll to the top. I think I'm going to do them in order. So we have a tip over here from Anna. Says, did Assange ever testify on his own behalf? If not, do we know why? No. I mean, I've never seen or heard Assange, you know, I mean, there were some times where he spoke out during the, sorry, I think I switched by accident. There were some times where he spoke out during the court proceedings in defense of Khaled al-Masri, who was tortured by the CIA. You know, Assange said, I won't let a victim of torture be silenced, something along those lines. I'm paraphrasing. But no, he didn't actually, as far as I recall. I mean, I might be mistaken, because I'm thinking, I can't remember anything as of now. Maybe in February, but not this February, but last February. But I'm not sure. I have to double check. But for you know, in general, just to give you an idea, for the most part, Assange doesn't say anything, which is, you know, he just sits there and has to listen to people arguing about his mental health in front of him. It's extremely, I don't know what to call it, upsetting, insulting. It's everything, you know. It's crazy. He has like these people who are in front of him out to get him. It's crazy, you know. That's what it looks like, and nothing could underscore that more than today when he was, you know, you could see him sitting in the room, and then at the same time they're arguing. You could hear the audio in the background about, oh, he's a malingerer. I mean, they didn't say that word, but they're implying it. It's really crazy. There's a tip here from Sora. Thank you very much, Sora. It says, I dreamed last night that the judge, not sure which one, was indicted for attempt to murder Assange. Then that judge pulled out a knife to kill the informer. Today, as I think about that, these judges do need to be held accountable. Well, I mean, some people surely view it that way, that the British judges, if they allow Assange to be extradited, then, you know, and we know that there's a risk of suicide, that they're complicit in murder. Well, let's see how they rule, because so far Judge Bretzer has ruled against extradition, although, I mean, it wasn't a satisfactory ruling. Yes, it's satisfactory in the sense she blocked it, but for the wrong reasons. So let's hope that they rule in Assange's favor in the appeal as well. The problem, though, is that they're keeping him on remand in Belmarsh. There's no need for him to be there, you know. So this is also a problem, that even if they rule in his favor, at the same time when it comes to a bail hearing, they're not. And this is contributing to you know, degrade his health. This is very bad. Sora says, adding to this to say thank you for being there and reporting over Twitter constantly this morning. You're very welcome, and I thank you for the support. I try my best. So I will be there again tomorrow morning, 10:30 a.m. London time. So again, you guys need to calculate what that is for you, because I think that must, what is that for you in New York? 5:30 a.m. East Coast. That's 2:30 a.m. I don't know. But it's 10:30 a.m. London time, and I will double check and let you know on Twitter. And thank you so much for tuning in. I'm glad that you guys are seeing everything in real time, because I try my best to explain what's going on and what they're saying, and it's very important, because it's not, you know, they're not going to televise this. You won't see Assange get, you know, a 60 Minutes interview or go to testify in front of Congress. No, they're trying to, you know, they're trying to hurry this through as much as they can, unfortunately. Yeah, so yeah. All right, guys, I need to get rest, recharge for tomorrow. I'll see you then. Follow on Twitter for the live updates on the court, and if not, we'll also be here on YouTube afterwards. I was also on RT earlier, so if you want to go check that out as well, I'll post it too. Thank you guys very much for your support. The collective also sent something on Rockfin. Thank you so much. I appreciate that. Again, thank you for supporting not just my channel, my reporting, but the reporting of others who are covering this, doing independent journalism. I really appreciate it. It goes a long way. All the links are below: PayPal, Patreon, and so on. Thanks for tuning in, and I'll see you guys tomorrow. All right? Take care. Bye-bye.